hospitality industry, has got majorly 4 branches. The one is accommodation service. The second one is the food and beverages. The third is tours and travel. And fourth is that event management, what they do, banquet services. So any hospitality industry can be branched into these 4 baskets. So today what we are going to analyze and understand is one branch of hospitality service, which is accommodation services. So when I say hospitality, when I say accommodation services, it is learned from the basics, like, what is an accommodation service and how it has been treated in the law. If you look at service tax, please correct me, sir, if I'm wrong. This is just my understanding from, the definition and, limited reading. In service tax, the idea of, taxing the accommodation services was simple. Wherever there was a commercial building, say if you have a commercial building, irrespective of whatever activity you do, like even in a commercial building, you can live, like, you can run a family. Okay. And in a family, in a residential building, you can run an office. Doesn't matter. The law was interested in understanding whether what is the nature of building, if the nature of building and the period of stay, right? If the period of stay is less than 3 months, and if the the building is of commercial nature, they wanted to tax it. Very simple. If it is a residential, they didn't want to tax, because residential building and it is given let out for residents, no tax. Commercial building, irrespective of the, whether it is residential or commercial or office purpose or whatever may be, service tax was levied. So they made it very simple, because the intention of law was to tax the commercial property and not the nature of transaction. They were not looking into the underlying transaction and then taxing it. That's how in service tax it was levied. But what they wanted, this government probably what they wanted, they also wanted to make it very simple. Let us not tax the residential purpose transactions. Let us make it very clear. Residential purpose transactions ought to be, should be gone out of tax net. All commercial transactions should be brought to tax, irrespective of whether building, not building. They wanted to make it very, very simple. With this intent, what they did, they introduced in notification 12, if it is for residential dwelling, residential purpose, it is exempted. Very clear. They brought out in the entry number 12. And further, for home, like, for a hostel or other services, any kind of stay, short-term stays, they wanted to bring in some benefit. They thought, okay, less than 1,000 rupees if you charge per day, then let us exempt. Apart from this, if you, anything apart from residential will be taxed. Any person, irrespective of whether, the residential is used for, commercial, or irrespective of anything. If it is purely residential dwelling, it is exempted. So they thought that this is going to, solve the problem of previous service tax, and they thought it will be very, very simple. But unfortunately, these 2 entries end up creating a lot of issues because of the loosely worded or the interpretational issues what lawyers have created. So that's how, it went into different direction. So when there is a notification, when there is an entry, it is very important for us to understand the correct meaning of it. One more, if I say it is a mistake, it will be bad on my part. Probably they have missed it. One thing which they really missed was that they should have given the definition of what is a residential dwelling, what is the renting services, what is accommodation services, all that if it had been defined somewhere in the notification from day one of issue of notification, that is from 28th of June 2017, we may not have faced this many problems. But what they did, there was absolutely no definition in the first notification itself. So they straight away started with accommodation services, renting, residential dwelling. These entries were, if you look at, let me just take you through that. If you look at your screen is visible, no? So if you look at here, entry number 12, there are two headings, 9963 or 9972. Okay. And services by way of renting of residential dwelling for use as residence. On the face of it, it seems to be very, very simple, because they are particularly, they want to, stress on the residential dwelling. Nil, no condition, no rate. Second, services by a hotel, inn, guest house, club or campsite, by whatever name called. You call it by whatever name. Okay. For residential or lodging purpose, having declared tariff of a unit of accommodation below 1,000 rupees per day or equivalent. Okay. So this is very clear. This is how it has been worded. Only problem is that we don't know what is renting. We don't know what is residential dwelling or what is residential purpose, right? So when we have to, when there is, it's a general law, when we don't have definition in the statute, we go by General Clauses Act or Black's Law dictionary, and whatever is a trade parlance, we take to derive. Everybody interprets and comes out with their own theories of this is how it has to be, understood. So when in the argument is placed before any court, they come out with their own theory for any definition you give, which is not found in the particular statute. So it's more like, anything you give, I can spin a story around it and then give, this is what it is. So what has happened when there is no definition for accommodation or, residential dwelling in particular, we go by the definition of general definition, Black's Law dictionary. It says that residence means, it's a general understanding. It's not even dictionary meaning. Residence means what? Place where one actually lives or has his home. Okay. A person's dwelling place or place of habitation, an abode, house, or where one's home is. Okay. It's a general meaning. Dwelling and residence more or less the same meaning. The house or other structure in which a person or persons live, a residence, abode, habitation, the apartment or building or a group of buildings occupied by a family as a place of residence, structure used as a place of habitation. Residential dwelling means any building, structure, or part of building or structure. Okay. But does not include. We are very, very clear what it does not include. It does not include motel, inn, guest house, campsite, house, lodge, houseboat, or like places meant for temporary stay. So what is the meaning of temporary stay is not there, but you are very clear that it is not a hotel. So that means anything more like a house will be called as a residential dwelling. That is what we derive from that. But that means anything which gives you the look and feel of a house for a short stay, for a temporary stay. It's not a short stay because it is not defined anywhere. For a particular period of time, it can be called as a residential dwelling. So, one second, I'm not able to. So then renting is already defined. Renting was defined sometime in 2018 and subsequently in 2022. Renting in relation to immobile property means allowing, permitting, or granting access, entry, occupation, use, or any such facility wholly or partly in an immobile property with or without the transfer of possession or control of the said immobile property, and includes letting, leasing, licensing, or other similar arrangements in respect of immobile property. That means when you formally enter into a contract with the tenant, so subletting is also possible, but still there are certain rights, right to possess, right to enjoy the property. So these rights are all given in the form of a contract of, when you're entering into a contract with the tenant. So that is a formal renting. And it has a contract, it has got a, a lessor, lessee, and you have a deposit. There is a formal contract is entered into, which we are all very clear. When it comes to accommodation, hotel accommodation means supply by way of accommodation in hotels, in guest house, clubs, campsite, or other commercial places meant for residential or lodging purposes, including the supply of timeshare usage rights by way of accommodation. So this is also clear. What is the meaning of hotel accommodation? So in hotel accommodation also, you can meant for residential. If you want to use it, you can use it for residential, but it will be called as a hotel accommodation. So this definition was brought in later. So the problem is going to arise only in the residential dwelling. So that's the reason why we spend some time on that. Then what is a declared tariff? In this, if you see, declared tariff was mentioned. Declared tariff is nothing but it's a composite, like when you're charging somebody a rent, which is including maintenance and, whatever amenities you are giving, clubhouse charges, or, housekeeping charges, or if you are providing Wi-Fi. So it is basically with the furnished accommodation if you are giving. So it's all inclusive is called declared tariff. Value of supply, we know as per section 15, valuation provisions are to be followed. It's a legal word, value of supply. Earlier, declared tariff was used. So these are all the important terminologies which we have to understand before appreciating the accommodation services and the intricacies involved in the in this issues, in this topic. So when I go on to the next, this is what the exemption. If I have to understand any topic, like, this is how I understand. So this is more like translation of my understanding about the services. So when this topic is given to me, I straight away go understand what is accommodation services, the basic understanding. Then I rule out one by one. Okay, accommodation services. So is there any exemption entry? Anything for that matter, just not only accommodation. So first we go on to the exemption. Section 12. If it is for services, yes, go to 12. And if it is for rate, you go to 11. So when I go to 12, first is that whether will it fall under general exemption. Say, is it falling under entry number 1, where if it is a 12AA, all activities will be exempted. So we have to see that. Then next is that specific exemption for that particular industry. Then you go on to the rates. Then you look at the amendments. What are the amendments with respect to those notifications? Then you see the circular, see the judicial pronouncements, and what is the law as on date. This is how we understand. So when I go to first exemption notification number 12, the first entry is about charitable services by an entity registered under section 12AA. Why do we have to read this first entry? Is that any charitable institution can be put into 4 baskets. One is for, health, other one is for education, other one is for, a public utility, any, spirituality or advancement of religion. And fourth is that now sustainability or environmental protection. So these are the 4 things which can get covered under charitable activity. So we have to see whether our industry is falling into these 4. So when I say accommodation services, it can very much fit into any of these 3, because one is that religion also. When I say charitable institution, there are religious institutions, say temples, or there are churches which gives accommodation. Say, for example, they take the pilgrimage tour, all the devotees, they take them to Vaishno Devi temple or somewhere they make them stay somewhere. So what would be the applicability of, will it be falling under accommodation services? So it will be some relevance, there would be some relevance. So we have to read that. When I say educational institutions, of course, very much, because when an education is provided in a formal or informal way, nowadays residential courses have become very common. So when they charge something for their students or attendees, what would be the implication, tax implication on that? So there also there is some overlapping effect. And next, when we come to healthcare also, if you look at it, hospitals also provide certain accommodation, either free of cost or at a chargeable basis to their nurses and hospital staff. So what would be the implication on that? Fourth, very general, very common, the corporates, any corporate, any commercial entity charges some portion of it or gives it for free to their employees. Their you call it as guest house, or you call it as a accommodation, or you call it as HRA, whatever it is, they are giving it something as a fringe benefit to their employees. If that being the case, what would be the applicability of GST? So these are the things which we have to understand and analyze and relate it with these provisions. So when I go to that, specific exemption, as I showed you before, only these two are there. One, if it is for residential dwelling, then it falls under 12. If it is in the form of hotel in guest, then it comes under entry 14. That also blanket exemption with the condition that 1,000 rupees per day. If it is anything less than 1,000 rupees, it is exempted. More than that, it will not be exempted. So these are all the exemptions, related provisions. Now, the problem came from various angles. From 2017 to 13th July 2022, almost for 5 years. The reason why I am saying is that, the problem, taxpayers are the ones which are, who are provoking the government to amend the law. Because when something is given, we want to, understand it in a better way, twist it, tweak it, and then make it suitable for our own style of business, to enjoy the benefit of whatever possible benefits. I don't want to say it's right or wrong. Nothing wrong. If there is a loophole, every taxpayer will try to, get the maximum benefit out of it. So that is what has happened here also. So when I say, blanket exemption, charitable institutions started, I am a charitable institution. Will I be eligible for this accommodation services by entry number 1? Because it says all activities. I have a 12A exemption. So why will I not be eligible? That is number 1. Second, why can't I fit in? Because I am only providing, even if you are assuming I am providing like a hostel, I am charging less than 1,000 rupees per day. Why will I not be fit into entry number 14? So these issues started coming out. This is charitable institution. Even commercial coaching centers, say for example, say masterminds. Masterminds also provides education as well as, this stay in-house, the students go and stay there. They charge some nominal fee, either along with the tuition fee or in a separate form. So when they charge it separately from students, why should it not be fit into entry number 14? Because it is charging 14. No, it is charging less than 1,000 rupees per day, which is also a right argument because it is clearly falling under that. Third is that there are individual, say I own a house, I want to give it for working professionals as a PG, where one living room is bifurcated into 2 and 2 cots are put, and I am charging per cot basis. So since I am giving the look and feel of a, residential dwelling, it's more like a second home for me, with the proper protection, with proper security and proper, food and lifestyle as good as your own home. Why can't it be fit into the definition entry number 12 as a residential dwelling? Then there are so many, business owners, like, business entities, they were running it like a business. They were running, PGs were run like a business. When they were running it like a business, they also started coming out saying, though I may call it as a PG. Yes, I'm running it for commercial purpose. But this hostel or PG accommodation, it gives the look and feel of a home. So I will also fit into the definition. So why I should pay tax? I should also be given exemption. Likewise, so many, like if you look at the advance ruling, in particular in Tamil Nadu, I have not taken much time in understanding the other state. I just, verified only the Tamil Nadu. From 2017 to 22-23, almost about 70 advance rulings on the same topic, on the same question, on the same exemption entry number 12, only on the PG. It means that earlier they were paying taxes during service tax. That's what I suppose. Maybe please correct me if I'm wrong. They know that they are running it for commercial purpose, but still they wanted to take the exemption. So then what the government did? Then the government took up the no, there is something has gone wrong. So they introduced the amendment in the year 2000, before 19 only. Then they introduced notification number 5. They said services by way of renting of residential dwelling to a registered person. Only one amendment they did through RCM, which is amendment of original notification number 13. So if you look at it, 5AA, they introduced in notification number 5 in July 2022, services by way of renting of residential dwelling to a registered person. This was the first step. If you are renting it out to a registered person, that means I own a house. I am owning a residential house. Even if it is a residential house, if I am letting it out to a corporate who's a registered entity, this is step number 1. If I'm letting it out to a registered person, then the registered person will have to pay tax. So one, gap was fixed. So this was the first step. Then what they did, next they wanted to bring in they wanted to fix the other gaps. The other gaps were notifications, like, exemption notifications. It took a long time. I don't know why it took a long time for government to fix. Probably by the time so many advance rulings have been filed, they could have immediately done it. But I really don't know why it took a long time. This happened only in, 23. Probably they wanted to, give the opportunity for any taxpayer to reach the advance ruling, then appellate, AAR, then High Court, then Supreme Court. Why it took long time, I don't know. But what they did in the notification, they deleted entry number 14 itself. They deleted entry 14 sometime in 22. So till 13/7/22, these problems were all there. Which entry was deleted? This entry was deleted. This was omitted on 13/7/22. That means if you are running like any hotel or by whatever name called, there's no entry. Residential building, residential purpose 1 exemption notification. Then straight away you go to notification number 11 for rates. If you are running it like a hotel or, in the form of hotel, if you run it, go to notification number 11. No other exemption, this or that. Then what they did here also, if you look at it, there were 2 headings, 9963, 9972. This also they wanted to, fix. Then what they did, they went to the, I'm not getting into the various amendments which happened, which had taken place in the notification number 11. I'm restricting it to only the exemption notification, because if I go to rate notification, there are too many. Like earlier it was at 28%, then they brought it down to 18%, air condition without, those are all relating to food. So since we are not food and beverages, since we are not covering, I'm just skipping that. As far as the rate notification on accommodation services is concerned, as on date, if it is less than 7,500, more than 7,000, up to 1,000 anyway, it is exempted. 1,000 to 7,500, it is at 12%. More than 7,500, it is at 18%. This is what it is. In between, there were so many changes at different point of time. So then when I have to say what happened, now let us understand what was the, issue which made them to amend the provisions, what we are adopting today, what is standing today, is that first is that I'm just taking out only the Karnataka High Court judgment, wherein there is a Tagar Vasudeva Ambarish. He is the owner of a property. Of course, he was owning it with 4 other co-owners. He had let it out to another corporate. In turn, the corporate had sublet it, or they were running it like a hostel, like a PG, like paying guest accommodation. So the question before the authority was that I am letting it out to some X. He is running it as a PG. I am letting it out as a residential dwelling only. I do not know what my tenant does or my lessee does. He may be using it for his residential purpose or commercial purpose. That is not the matter of concern for me. As far as I am concerned, I am the service provider. I am providing only residential dwelling services. Why should I not be claiming the exemption under notification number 12, entry number 12? Why should I not be fitting into that? That was the question before the authorities. Authorities, it went to 2-stage appellate authority. Advance ruling authority, then appellate. I think they did not go to appellate authorities. They directly went to High Court. Writ was filed. So then the High Court looked at the matter. See, one thing which we have to understand is that, which I could understand, is that as far as the High Court is concerned, they are not here to fix the loophole in the law. Whatever is that fact, whatever is that provision, they are just directly applying and then giving the verdict. So it is for the legislature to ensure that they don't leave any room for these kind of mistakes. So what they did, the petitioner put forward his argument saying that same argument, residential dwelling. When I'm giving it for PG accommodation, whoever comes and stays here, use it like a home. This is the second home for them. It's same set of arguments. They use it like a home for them. I give them security, I give them food, I give them the comfort of a home. So it is for a shorter period. Shorter period, it's also not defined. It can be for a minimum period of say 90 days to 1 year. So they use it as their residence also, residential proof. Like, if you want to give any address proof, that is also, these PGs are used. That being the case, why should I not be given the exemption? So the High Court looked at it and they said, perfectly fine, because as far as you are concerned, the entry is concerned, the plain reading of the entry is concerned, it does not say that, it does not say that the service recipient should not use it or the service recipients should not sublet it. As far as the contract is concerned, it is given for residential purpose. As far as the nature of transaction is concerned, yes, it's your PG accommodation is also more like a residential nature only. So it very clearly fits within the definition. That's all. It's only limited to that. The question was asked, yes, whether it is fitting in. Yes, it is fitting in. So High Court quashed the impugned order of the lower authorities, like advance ruling authorities. They started enjoying the benefit. So because of this, High Court, since it's a High Court of Karnataka judgment, so many, like if you look at, I'm saying about 70, the number I'm giving may be lesser also, 70 to 100 advance rulings were filed on the same topic, on the same issue by the same set of PGs. So everybody wanted to enjoy this benefit, so they have filed it. Then out of that, one went to Thai Mugambige Ladies Hostel. This is in Coimbatore. This went up to Supreme Court. They same question, whether notification number 12 is applicable, is registration. First thing is that is registration required because it is not in the nature of business. It is not in the nature of business. maybe 20 lakhs, below 20 lakhs, or more than 20 lakhs also, if it is exempted, why should I take the registration? So what is the tariff entry? If that be the case, what should be the entry or code under which, HSN code under which I have to be charging? And since I have the judicial precedence of Karnataka High Court, why can't I apply and then go with that? So this was the question before the advance ruling authorities. And advance rule. And one more thing, see, when they go to Supreme Court, they also, to strengthen the arguments, they even looked at the allied laws. There are so many allied laws for any, any transaction, any commercial transaction. So to substantiate their argument, they said, we are referring to, Zoning Regulations Act. We are referring to Rent Control Act. We are referring to Shops and Establishment Act. So many acts are referred to prove the point that it is not in commercial nature. Okay. Unfortunately, they did not go to the electricity department. Whatever is their favorable, arguments only, favorable points only they were putting forward. One simple reason could have been, like, if they had gone to electricity, obviously they would have, electricity department wouldn't have given the, connection or load. I mean, depending on the load only, the electricity department decides whether it is a commercial or residential. If it is of a residential, then the load is to certain extent. And if it is a commercial, it will be at a commercial rate beyond that load capacity. So, but they did not go to those kind of departments which will say that it is of commercial nature. They particularly went to those, take shelter under certain laws, which will say that it is of residential nature. So what they do, I enter into agreement with the, with the inmates, where just like a rental agreement only, it's more like a home. So they give their residential, for opening bank account also, they use this address. These are the arguments which they were placing before the Supreme Court. So when they, put forth their arguments in front of the Supreme Court to prove that the hostel or, paying guest accommodation is akin to the residential or home, the High Court had no other choice. They know, everybody knows, not you or me, everybody knows that the paying guest accommodation is for commercial purpose. There is a profit motive, and it is not a residential. It has got residential plus. It is not in home also. You don't get everything, right? If you pay something, do you get everything at one place? Like here you have Wi-Fi, television, all comforts you get. So definitely it's not like a home. You get laundry, everything you get. But when you present your case before the, High Court, Supreme Court Supreme Court, they have to look at the transaction. They have to see the argument, how it was placed before them. They have to see the facts, merits, and the connected statute. They have to give the verdict. No other choice for them. So they said, it is, though it is a, they did not say though it is a commercial. The question was whether it is a residential. PG, paying guest accommodation or hostel, is it a home? Is it more like a home? They said yes, because of the facts what you have given, it is more like a home. If it is a home, then look at the entry number 12. It says very clearly residential dwelling. It's more or less the same entry, no other entry. Okay, you take the benefit. Whether it should be given for commercial or, that purpose, that is not. So that was the question placed before the Supreme Court, and applicability of GST as per the entry given is nil. It is exempted. So same way here also, whether you run it or you sublet it or your lessee runs it, irrespective of whatever may be the thing, the nature of the transaction, don't look at the transaction, look at the nature of, look at it from the end user, look at it from the customer angle, service recipient angle. When you look at it from the recipient angle, it is the transaction is purely of residential in nature. He comes to the the PG thinking that this is going to give him the look and feel and comfort of a home. So it's purely looked at from the end user perspective, and this judgment was given. So with this Thai Mukambigai case, reached up to Supreme Court, and after that only, like, the government, the CBIC thought, okay, so there are certain changes are to be done. Slowly they started doing the amendments in the notification number 12, and in particular entry number 12. And also they had to bring in another clause exclusively or excluding this hostel. They know that these people are notorious, so something has to be done. So they thought, nothing doing, let us learn the lessons from service tax, how it was there in service tax, short term, 90 days. Let us bring in that, specifically highlighting that, let us make it very clear. With that intention, in 2024, they introduced that clause 12A. After 12A was introduced, after the 53rd GST Council meeting, they said for a short period, anything less than 90 days time, 20,000. Let us fix the quantum. Let us fix the time. Timeline, and let us fix the purpose. If these three things are fixed, then it becomes very clear. So with that, they introduced one clause, introduced one entry. So that is done. And then when it comes to exemption, so now it is very clear, only two exemptions. One, if you are running it only for residential purpose, only for residential purpose, there is no GST. Today also there is no GST. Apart from that, you call it as a home like, or it's any other purpose or whatever it is, then it goes to the next entry, 12A. Other than that, that is short period. Other than that, anything you do, it goes and sits in the notification number 11. So there is no confusion now, as of now. But still, interpretational issues may arise depending on the case-to-case basis. So this is the summary which I have plotted. If it is accommodation, just to summarize, general exemption, residential dwelling which is exempted, hotel accommodation which is taxable. So up to from 7/17 it is exempted. 18 July 2022 they introduced RCM clause. 13th July they introduced, and then 18/7/22 there was one amendment was made in the same entry, making it as unregistered. That means if an unregistered person giving it to a registered person, then there is a RCM, or there is a change in the entry. Then from 15/7, as I said, 90 days. So these are all the summary of it. As of now, if the exemption is only given for renting of residential dwelling for residential purpose to the person not registered under GST, only will not be taxable. Rest are all taxable. And anyway, this we are not dealing with it below 1,000. So 9963, 9962. So whatever happened. So government can also make errors. That is what I could make out. I mean, maybe I may be wrong, but yes, government has made some errors. They could have worded it correctly, but after the issues started cropping up, they could manage it and then amend the provisions. So as of now, 9972 residential dwelling, which is exempted, and 9963 supply of accommodation services, that is also exempted with the condition. And rest are all, these are all the 9963, 9963 to other accommodation services. It has to fit in clearly in any one of this, because other room or unit accommodation services. So they have brought in here So you cannot go to here 9972 and then take shelter for paying guest or hostel, because they have clearly said this is only for residential. So residential and hotel, hostel, paying guest accommodation, these are all clearly distinguished after Thai Mugambigai's case. So this is just the, since he calls it as a tale, I'm just ending with the moral. Error is human. Good that if you are able to ask professionals at the right time when we are reading, if we are able to identify the ambiguity in the law, definitely we can, advise the client. So, okay, this is what the issue here. You can go as per this, so that when any problem comes in future, there is a real lapse in the notification. So you can, nothing wrong in, you are not bending the law. So definitely you can make use of the missing link in the notification. You can we could have advised the client that way. And question of law, whenever there is a loophole in the law, we have to be very clear and we have to ensure that the interpretation is sought or interpretation is, reached. We get the clarity by going to Supreme Court level, because the Thai Mugambigai case, if you look at it, they could have stopped at advance ruling, or they could have decided, no, we are not eligible. We know that we are commercial entity. We know that it is a profit motive. We know that it is not a residential. They could have stopped and then they could have started charging or collecting GST. I don't know, in the service tax period, I'm sure they would have collected, but still they wanted to make use of the provisions in the law. They wanted the government to make it clear that you tell me that it is not, then only I will obey. Otherwise, I will, if there is any loophole, yes, I will exercise my right. So they have gone to Supreme Court to get the clarity. I would say, yes, nothing wrong in getting the clarity. And when we know that there is these kind of interpretational issues are there, when we advise, we should also see the problem. When it's my personal thing. When I read it, oh, maybe this change, that change, this change, I could not appreciate why they are making the changes. I could not see or foresee, I would say, I could not foresee these are the things might come up. One day this might change. I could not appreciate. I could not even understand. I was feeling so happy. Oh, okay, when PG accommodation is exempted, Supreme Court judgment has come. I didn't even realize why, for what they have done, what is going to come up. So when we understand from beginning, good that this topic is allotted to me, because I was able to see the holistic picture of this issue. So maybe whenever there is some judgment comes after knocking so many doors or after reaching various authorities, that means there is a real issue in the provision statute, and government is also trying to fix it. So before fixing it, what are the things which we have to take, or before, when the issues are happening, how to safeguard our clients, also one of the good ideas. And looking at it from the opportunity side, making it very clear, this is the cutoff date, this is the amendment date, up to this date you can take this exemption, beyond this date you cannot take this exemption. So it gives the clarity for us to understand the law and comply with the provisions in a better way, so that tomorrow any notices are issued, we will be damn confident at that point of time that was the law. So you cannot go back and then tax it as per the law what is today. So we'll be in a better position. So now the circular has also come. I think in July it has come. So that circular is a beneficial circular. They have said probably government has also realized that they have done the mistake. So what they have done, right from 1/7/2017 to till date, they are going to treat this issue as is where is basis. till 14th of July. That means what is going to be the effect of this notification? Is it going to be retrospective, or the circular, can we take the exemption from beginning, or how do we have to deal with this? People who have charged, can they claim the refund? So these are the open issues which are, present as on date. So with this, I, close my discussion. Thank you so much for giving me this opportunity. Now the floor is open for discussion. Sir, I'm over to you, sir. Over to Venu. Thank you.
Madam, some questions I put it in the chat.
Okay, I see that.
And others can put up your points before we ask Jatin sir to add his views.
Yeah, up to 1,000 no longer there for hostel. Correct. That entry is deleted. 14 is deleted. Paying guest accommodation is residential for recipient, but commercial for supplier. Correct. Electricity department categorizes category based on nature of usage. Correct. It's all self-assessment, whether it's a property tax or it is a electricity, unless and until you go and tell them. But the minute the capacity increases, probably they will have some mechanism to find out whether you are using it for a commercial or residential. What? Okay, 9963.
Here, Sujata, what I meant was, see, you're talking about the capacity of the usage as such. So if we get into, for example, we have apartment complex, see, 100% there the deposits are going to be on a higher side because there are multiple houses or multiple units in the same category. So they have something called as a, what is it called? High or low category of transformers itself. Based on which they will have a single master meter, which has to be, and we have to pay the bills according to that particular transaction. So it is not with respect to the usage. The usage, probably it makes them to categorize it based on usage of the number of units per unit. Are you trying to tell, is it going to be categorized as a commercial space?
See, there are two things. One is a slab rate. Obviously, even for residential purpose, there is a slab rate. If it is for commercial, then the tariff rate itself is going to be higher, depending on the usage. Say, for example, I'm living in a, say, 1,000 square feet house. The maximum can be, electricity can come up to, say, 3,000 to 4,000. Whereas if it goes to 8,000, 9,000, then in the electricity department also, it will create some alert. For 1,000 rupees, 1,000 square feet, how come there is a huge load? The load cannot take, no? Capacity is also.
Okay. Maybe what they do, if I'm, as per my knowledge, is they come and verify whether there is a residential accommodation only, or is it being used for commercial activity. Only if it is used for commercial activity, then they will convert it into a commercial rate as such, basically.
So when they come and use it for commercial rate, it becomes commercial, no? When they come for inspection and do it.
No. There they have two things. Again, they will first, if it is only for residential category, so for each extra unit which is being used, they will have a slab, say up to 500 units, up to 1,000 units. So if it is crossing that particular thing, if you are in the first slab, say up to 500 units, then the deposit would be X amount. So if it is becoming, say, 1,000 units, then you have to pay higher deposit rate. Only that I have seen. But generally, they may not classify it as a commercial, is my knowledge. Okay.
Yeah. $9,963 accommodation, 12% and 18%, no exemption. YPG is 9,963 clarification. No, currently 9,963 and 9,972 only. Who's 9,963 people in this entry? Services they are renting of residential dwelling for use as residential except where is entered into registered is exempt or 9963 and 9972. See 9972 you have various subcodes, right? 9972 if you look at it, 9963 has got various HSN has got various subcodes, subheadings, but 9972 is only one, no? 9972 is, there are only two entries now, 9972 and 9963. 9972 is for residential dwelling. If you are giving it to a registered person,
Madam, 9963, is there any residential dwelling?
no, there is no.
The exemption entry is for 9963 and 9972.
Correct. 9972 is for residential. 9963 is for others.
Now, what is an exemption in 9963 is my question.
In 9963, see, it starts from 1000 to, okay, that means it is a below 1000, it is exempted. Is that what we have to understand? If you ask me below 1000, is it there? Entry is there. Below 1000 entry was omitted. Below entry was deleted. 14 was deleted. So explicit below 1000 entry is not there. But if you look at the rate, it starts from 1000 to 1000 rupees to 7500.
Even that is omitted, madam. Even that is 1000.
1000 to 1000, 7500 for 7500 is there. No, over and above 7500 is at 18.
No,
And
below 0 to 7,500 is 12 now.
0 up. Okay. So that means that 1000 itself is not there.
correct, but my question is not that. My question is,
Huh.
the services by way of renting of residential dwelling is exempt.
Correct.
Now that exemption is there for 9963 also.
9963 also.
Correct,
Residential.
correct. So my
Okay.
question is, why do you say PG is 9963? So if it was PG was 9963, was this exemption was fitting under there? Because it is a residential dwelling. We see
Residential
that
dwelling.
notification 12.
No, see, now they are making it, don't connect PG with residential dwelling at all. That is the understanding which we are deducing from after this, recent notification.
How?
Don't call it as a residential. They are classifying it as differently. If you see that there were two explanations were also added. Two explanation. One was added. I'll give you that correct notification. See, if you look at it, two explanations were added below that entry. That entry clearly says that if you are doing a residential dwelling or PG, don't come here. It does not include. I'll tell you what is that. Second, I'll tell you that.
Madam, my question is simple, madam.
Ah,
What is the residential dwelling under 9963 which is exempt even today?
9963 residential. Residential will not come here, I'm saying.
So if you open notification 12, the exemption entry, can you go to the exemption entry for notification 12?
See, if you want to call it as a long period of time, like, then you can call it as a residential long period of, that is the only entry available under 9963.
What is it? Can you give me that example? So he is paying as taken for 12 months. Irrespective of
5
the
months,
amount.
5 months. I am renting a
No,
place
I'm
for
saying-
5
I'm taking paying as 12 months. Every month I'll pay 50,000 rupees. Is it exempt?
Every month you are paying 50,000 rupees.
Correct.
Okay, so is it falling under 9963, 20,000 per month per person?
I am only saying that what is an exemption for 9963 is my question. That's all my questions.
Venu, 1 minute.
Yes, sir.
If you see the opening para of 12 or 17, there is no reference to HSN code available in column number 2 to guide the description provided in column number 3. So your question is very relevant, but that's only for us to understand, but not test the thing, because HSN code number 2 is not relied upon to decide the scope of column number 3.
Agreed, sir.
So therefore, your question is important only for academic purpose, but will not be able to give you an answer because it has no bearing on the interpretation.
When, if you.
So column 2 does not have any significance at all,
No,
sir.
no, does not have anything. It's only for reference.
So it is, I have to only go by in a column
Description.
description.
Correct.
Got it.
Clear now?
See, 9972, if you look at notification number 4/2024, with effect from 12th July 2000, it clearly says 2 was added. Nothing contained in this entry shall apply to accommodation services for students and student residents, accommodation services provided by hostel, camp, paying guest and the like.
No, I agree, madam.
No, okay, about that, then I'll give you one. I'll give a small example and then answer this question. Everybody who does auditing is not a chartered accountant. Everybody who can prescribe a pain medicine is not a doctor. You agree? There is something called valid authority to supply and actually supplying something. Everybody who supplies will not be allowed to use the HSN code. For example, Byju's cannot claim to be education institution. Like Puttur Bone Setter cannot use healthcare service exemption. If you keep those examples in mind, nobody can use HSN code 9963 unless they own the immovable property where they're running accommodation, or they have taken the immovable property on rent or lease to run an accommodation service. So therefore, wherever the legal authority to use HSN 9963 is available, 9963 only should be used. Where authority does not exist, 9963 cannot be used. You will find the basis for this in explanatory notes to the scheme of classification of services under 9972, where it says it does not include. 9972, it does not include. In that context, it says you cannot do this. You consider that, then I think it should help us get an answer.
Sir, a license which extends for a long term will still be 9963 only, not?
Again, like I said, HSN code is not relevant, so we should not go into that debate. Go into explanatory notes to understand whether you are using 9963 correctly or you should be under 9972.
Yes, thanks.
See, just one point, I don't want to debate anything that was presented. Just one point to consider. Whenever you are reading a notification, please either use your own understanding of the expression, either use your own expression of the understanding of the terms, and or you go by the statutory definition. We will use our understanding of restaurant but there is a statutory definition of restaurant provided. We will use our definition of education institution, but there is statutory definition provided. Similarly, if we use common sense understanding of accommodation, we are not giving the required weightage to the statutory definition of accommodation provided in the notification. Point number one. Point number two, please look for whatever answer you come to, find a way to test the validity of the answer. Now we have discussed about 12 and 14 at length. All the judgments have also discussed 12 and 14 and given their own logic. But if you please see what's happened is, if 12 and 14 were, if 12, entry number 12 was sufficient to result in Tagar Vasudev judgment, why do we have entry 9D? After all, entry 9D deals with old age home. Why do we need entry 9D when 12 was sufficient to cover PG? Therefore, Tagar Vasudev may have been rendered sub silentio. If you look at entry 9D, it talks about old age home. How different is a old age home from a PG? It is exactly the same. A commercial organization today, corporate entities are running old age homes because it is so lucrative. If 12 was sufficient to cover PG as held in Tagar Vasudev, what was the purpose of 9D? If you analyze, you will come to know why this judgment was wrong, and then Arvind Dattar appeared in Tagar Vasudev, so that effect may have been in the judgment, and so on and so forth. So therefore, this point is, the second point is, please don't be satisfied with the conclusion you have reached about the interpretation of an entry without testing the correctness by internal validation where similar words are used in other entries. Another example for this is, if you see entry 74, which talks about homeowners association, there it talks about up to 7,500. Now you please see up to is used in 9D also. Whenever you say up to is a standard deduction like section 16(1) of the income tax law, can we say that the same thing operates in entry 9D? This point we have to consider after we have read and understood. We have to test the correctness of the approach we are coming to by internal rules of validation by comparison. And just one last point. Sunita ma'am, can you confirm Sai Bhukamika was Madras High Court or was it Supreme Court? You can confirm now or later.
Sir, it Madras High Court.
And Krishnan, Justice Krishnan was the single member judge of Madras. Please confirm that.
Sir, you.
Venu, column number 2, I told you, leave out column number 2. Don't read column number 2 for understanding, but don't quote column number 2 because it has no legal significance.
Agreed, sir. So
It's
somewhere,
Union of India, sir.
even they didn't want to take a
Oh, sir.
position. Either they should have specifically put it as 9963 for old
No,
age.
so therefore, now you understand how irrelevant column number 2 is.
Correct.
As you keep asking more questions, you will come up with questions like this. So therefore, they said, I don't know what to do, everything under chapter 9.
Yeah, correct.
See, age of the person deciding has no relevance. Now,
Absolutely.
I'll give you an example. What about old age home run by a corporate entity? Will it fit within service apartment exemption? It can't fit in 9D. So therefore, should it be 20,000 rupees? You
But
understand? Look at all this.
if they take 12AA, sir?
No, corporate entity won't take 12W. No, it's not Section 8 company. Private company is going for VC funding, running old age home because of the aging population. If they find it is lucrative, can they fit into paying guest accommodation? Entry 12 AA. If they keep it below 20,000,
Yeah.
no, not possible because the 90. What's the time age duration of stay?
Duration of stay is longer only, no, sir?
90 days.
Hmm.
Minimum of 90 days. So it's long term duration. So
Correct.
therefore, so old age folks. So therefore, there are none of these things have been fully answered,
Yeah,
isn't it?
correct.
Okay.
But if they can put themselves under with this new entry PG, no, sir, now the corporate.
Possible. If they put under now, let's say there's a judgment that comes saying that corporate old age homes is 12 AA.
Huh.
What happens to corporate service apartments prior to 12 AA? Where are they going to provide? How do you argue?
Hmm.
If you say that you are relying on as-is basis circular, that
Hmm.
means you're admitting liability. Is that a good defense or is a defense based on
Convenience.
in department? So we have to, our study should take us through all those aspects and not by, because we should not sort of rely on the statutory definition when it is suitable, leave the statutory definition when it is not convenient for our answer. Because a conversation or a discussion cannot start with a conclusion in mind. That we'll have to guard ourselves.
So the another challenge that would come up is now they will unbundle the thing, medicine separate, medicine on actuals as a separate thing, build, and accommodation put to 20,000 rupees, claim an exemption under this entry.
But then they have to be clinical establishment to fall under 74.
Hmm.
Otherwise, it will be goods.
Yeah, medicine would be
Chapter
goods
30.
and taxable.
No. Are they selling goods to the residents,
Hmm.
senior citizens, or are they providing them healthcare also? But normally they will also have a clinical establishment register.
Hmm. Okay.
Okay,
Yeah.
but I think
Yeah.
I'm
Yes.
taking this in a different direction. But
Yeah.
please test these two aspects.
Got it, sir.
Don't forego the statutory definition and then test your conclusion by internal validation and not stop after reaching a conclusion about the scope of an entity.
Got it. Got it.
Sir,
Okay.
I stand corrected that the I Mugambiya is not Supreme Court, it is Madras High Court, sir.
Single. Okay.
The other one was a division bench. That Tagar was there, is High Court of Karnataka.
Tagar was name was DB, is it?
Division bench, sir. Yes, sir.
But Tagar Vasudev, I think they have filed a SLP before the Supreme Court, I think. So.
Department has gone to Supreme.
Yes, sir. Yes, sir.
Court.
I think we have to look at the aspect of paying guest accommodation from two angles. One from the owner's angle, one from the tenant who is running the PG, probably.
No,
So
but look at
going-
this. Sorry, please correct.
So going forward, how should we look at this when we are analyzing it on a prospective basis, taking the cue from whatever has happened now? So can I still take a contention or a cue based on this particular thing, telling that it will, from the owner's perspective, that is where Tagar Vasudev is there, sir, where they are telling it is not taxable is what Karnataka High Court has given. But when we look at the department has already gone before the Supreme Court, what should be our thought process in that particular scenario, sir?
What will happen is the SLP is likely to get dismissed in view of 53rd Council decision. But if you go back and read Circular 228, the question that they raised in para 9.1 has not at all been answered in para 9.2. So therefore, what will happen to all these past cases is based on 9.2. All as is various basis, they will drop it. Those who paid won't get refund. So therefore, look at this point of view. I'll share. There's a small table that I had made. I'll try and share after the call about what happens. You can give some of your views about what happens in those cases.
Sir, the 20,000 rupees what I'm charging, that will be from the person who is charging as a PG person, sir. But when I am the owner, I charge say 5 lakhs or 10 lakhs per month is the rent. So in that case, what will be the scenario? Can it be considered as a per room basis or a per student basis? That generally how is the owners are fixing the rent today is approximately for how many beds and how much is the rent. They are trying to come out with that analogy. So this many beds per bed you are supposed to charge say 5,000 rupees, 6,000, 10,000 is the rent which is being fixed. So in this regard, can we take a contention that the rent is per number of people basis is what the overall rent is fixed, and can we do it on that line, sir? Then
My sense is you can't extend PG exemption when the supply is not of PG services.
okay, that is not PG service; it's only renting of immobile property. But can we
For
take it
commercial
under?
purpose.
Can
For
we take it
commercial
under the residential category, sir? Then
Under NT 12,
yes, sir.
it is given to if it is an see now again all those questions comes back saying if you are giving your residence to a registered person and you
Yes.
know that it is not going to be used as a home. It's not a RFA. They're going to run a business with it. See, in a PG or a old age home, it is not a residential dwelling for the reason that there is no kitchen access. You know, that's a altogether big topic of discussion as to what is residential dwelling. I'll just leave it at that statement because in the presentation we saw that residential dwelling not being defined was kept open.
Okay. And another one was with regard to the Sai Luxury PG, which was raised and the decision came last year, July, sir. So I think because of which, I think now they have come up with this exemption up to 20,000 rupees because they
Right.
tell it's services which are more than the required it is more than a residential accommodation because there's a washing machine, there's a TV, there is food which is provided, there are multiple services, Wi-Fi is provided. So based on that, they have Karnataka AAR had given that it's a taxable activity, sir, basically.
You're right. So therefore, advanced ruling authority seems to be consistent about what they look at these supplies as, and high courts have gone in the other direction. This is the point that Madam made about more than 70 applications having been filed.
Okay, sir. Thank you.
No, because of this, Nitin sir, no, because of this amendment that has come in July 2024, this Tagar Vasudeva, in my opinion, has been overruled. In
Correct.
fact, in Tagar Vasudeva, there were two kinds of transactions. One was this gentleman, he was giving on rent to a company. The company it was actually the company that was running the whole PG accommodation. There are two transactions, technically, as we understand. One is this gentleman, Tagar Vasudeva and his relatives renting it to the company in turn giving PG accommodation. Now, in my opinion, sir, that Tagar Vasudeva has been overruled. Yes, it has definitely, the SLP has been filed by the department before the Honorable Supreme Court. But even then, that since now it is overruled, I think whatever the judgment of the Honorable Court will be only applicable up to this time, up to this July 2024. Because by virtue of insertion of explanation 2, I think that has been overruled. So I don't think Tagar Vasudeva is a good law, as of now. That has been overruled.
I'm with you. Okay, I excuse myself.
Yeah.
There are no other questions, then we can close the session, Venu. Over to you.
Yeah, yes, madam.
Jatin sir, any other points?
Sir has
No,
left.
left, yeah, sir is left.
Yeah, any other points from anyone? Any other questions?
Venu sir, Jatin sir has shared that summary of as is various circulars. Since we have some time, can we just
Yeah, sure.
check that and kind of correlate for an understanding?
Yeah,
Sujata madam, can you share your screen with that?
Sharing.
I've shared.
Yeah.
Able to share.
Sir is categorizing the circulars into 3 categories. Exempt and regularize, exempt and clarify, clarify only.
First is past
So,
to date of GST Council decision.
hmm,
SCN is issued. SCN is not issued. Demand discharged.
yeah.
SCN is issued.
So if we, let's say 16.4 cases, no, that can we take up that example?
No, we can take PG only.
Okay. That PG circular, which category does it fall? Like exempt and regularize, exempt and clarify, or clarify only? Clarify.
No, it is exempt and clarify.
Yeah. So there is scope for issuance of SCN even if it is not yet issued also, subject to limitation under 73, not 74, because there is a multiple interpretation issue. So it cannot fit under 74. Okay.
So it's been the same has been exempted with effect from 1st July, 15 July 2024. It is exempted and clarified.
Oh, it's a prospective exemption.
Exemption is prospective and
Clarification is?
the historical is as is basis.
Okay.
So it is
So
retrospectively it is exempt and clarify.
Okay. So whenever there is a prospective exemption with respect to a matter,
We should treat it as retrospective exemption whenever it is as is basis.
No. Sorry, come back to that image.
Yeah.
Hi, Venu. Hello.
Yes, sir.
No, this particular thing as is basis is actually will regularize the past, exemption notification only future. It's only a prospective exemption. It is not retrospective exemption. Exemption cannot be read as retrospective. In fact,
Correct.
the fact that they are given as is basis would make the notification, intention of notification only prospective. It cannot become retrospective. But as is basis, because if it is said to be a retrospective, then what happens is the refunds will become applicable. The difference between a retrospective exemption vis-a-vis the as-is basis is, in a case of a retrospective exemption, there is a possibility of claiming a refund. But whereas in as-is basis,
refund, sir.
Sorry?
In exemption, refund will not arise, no, sir.
No. I'm telling you, if they give an exemption retrospectively,
The taxes
if somebody
paid will be claimed as a refund.
Yes. If somebody has paid a tax, he will get a right to claim a refund.
Okay, got it.
Okay, but if they give this as-is basis thing, then they will not be entitled for any refund.
But as-is basis also is a conditional as-is.
You mean, what do you mean? I mean by that? Okay. Hello?
Meaning, earlier if I've collected 25,000 rupees, then I am taxable. Earlier if I've collected 15,000 rupees, I am exempt.
No, I'm telling that that's what I was about to come to next point. See, by giving this exemption, they are making the liability confirmed for the past, for the other cases who are above the 20.
Correct.
Now, the litigation would continue in those cases. I can still try to take an argument, anyway, it's in litigation, the Tagore Vasudev issue,
Right.
and try to argue that that was not at all exempted. This cannot, I mean, there's a two exemption notification, one being generic, one being specific. I will apply generic. So sort of an argument possible in a litigation.
Right.
So basically,
For the
where if we take that same example what Venu sir took up, going forward, whatever is below 20 will have exemption. Whatever is above 20, I need to collect taxes and discharge. For the past cases, in the example what Venu sir took, 15,000 and 25,000. So I have already, I mean, if it is a 15,000, then they will not issue SEN.
correct.
If it is 25,000, subject to that 73 limitation, they can still issue an SEN, even for the past
Correct.
periods.
Exactly.
So now, why? Okay, because there is a confusion, we are saying 73. It is not 74.
No. I don't agree on that aspect of it. If they can go, even they can go for 74. It
Correct.
was not a confusion unless you take a stand at in the litigation that it was not at all liable.
Correct.
Then only you can get a 73. With
Right.
20,000, see,
Someone
it
is
is
collecting
little,
25,000. Department
Uh,
IPL can issue under 74 also.
see, now I'll come back to this. This as is basis is a tricky issue, tricky word.
Right.
Now, in this scenario, can I argue? I'm just putting across the argument. Can I say as is basis, it will be applicable even to a cases where somebody has charged more than 20,000. I mean, more than 20,000. So don't even touch me because regularized as is basis. Whatever I have done, accept it. That's all. Don't get into only, they didn't say, see, it's not coming by way of a notification to say in excess of so-and-so is exempted for the past.
Right. So that means
Okay.
I'm challenging the circular also.
Sorry?
So, what is this category over here then? Exempt and regularize, exempt and clarify. What, I mean, how do you...
I'm not getting into the categorization. I'm just telling because see, what Jatin said is for our understanding. But what I am getting into is a litigation perspective. I'm totally, I mean, I'm not getting into the that discussion. I'm getting into a totally different discussion. What happens if the notice comes to me? That is where I am looking into. If a notice comes to me, should I surrender and pay for the 20,000 and above? Because I am paying now, sir, now the taxes for the 20,000 and above.
Ideally, it should be exempt even if it was 25,000 above. Entry has come only today. So it is taxable 25,000 and above only from today is my view.
Sir,
So
one more
for
thing.
all
Right?
past periods, you mean to say everything is exempt, huh?
Correct.
How,
Rajesh
Venu
sir,
sir? How, Venu sir?
No, as is basis. Okay. So when you purchase some old house, I mean, some factory, as is condition or as is basis, whatever is there, it's there. You cannot again bisect within that something.
Rajesh sir, can I add here?
Yeah.
See, it is saying as is where is actually. So can we take it as whatever the position extra was there on that day? That is called as where is, like on that day where it was actually, at what position it was. Was it at the position of levy, or was it at the position of dropping, or was it at the position of refund? So can we read that as is where is, like on that day where it was? So that is a one interpretation. And recently I remember reading one of the Gujarat High Court on this aspect. I think it was on Papad or something. I can share that decision where they have analyzed what do you mean by that as is various basis. And in that case, they have interpreted saying that whatever situation was prevailing on that day with regarding to that status of payment of GST by the petitioners, it will continue to prevail. So can we apply that Gujarat High Court decision which was issued on somewhere on yeah.
Anpuna, can you just repeat what you said? As is where is means that whatever
See,
the position which was there, which means
on yeah. So like whatever situation was prevailing on, say, for example, in PG, if we are taking 14th July 2024 till that date, the as is where is it is. So where it was on that day, was it on the date of levy or was it on the date of exemption? And I also believe that there will be a separate circular to clarify what do you mean by as is where is, because even this Gujarat High Court decision also has interpreted saying that as is where is basis means it is the situation which was prevailing with regarding to the status of payment of GST by the petitioners. So
So
whatever
that
the
means they have
status
to
of,
pay tax. That
No
means to
need
pay tax.
No need to pay tax, sir.
no, I'm not saying paying the tax. I'm saying where it was standing on that day. That will decide
That's
actually.
exactly where it was means because the notification is prospective in this
Yeah.
scenario. Wouldn't
Hmm.
it be that, I was liable to pay tax on that basis?
Because the exemption is only up to 20,000, sir.
That is.
No. I see.
Yeah.
I'm not talking about this exemption because the phrase which we are trying to understand,
Yeah. Yeah.
as is where is basis.
Hmm.
See, I've seen three types of usage. One is as is where is basis. As is inverted comma basis comes outside the inverted
Yes.
comma. As
Yes.
is basis inverted comma. So
Yes.
I really don't see any real distinction because the agenda meeting always wanted in response to people asking to not to demand for the past cases.
Yes, sir. Yes, sir.
Okay.
But
Okay.
So
yes,
I mean,
Sir,
so
Rajesh sir, sorry to interrupt.
Yeah.
So this as is where is, now it makes more sense is like when Jatin sir said exempt and regularize, exempt and clarify only. So it can fit into any of these three, can we say that way?
See,
Yeah,
Venu sir, the previous circular what you displayed, it uses the word regularize. So that circular is an obvious fit into this first category, meaning thereby even if it is collected above 25,000, no new SCN is possible. Can you just flip that
Yeah,
document and
I
show
will
that?
do that, but I want to have my understanding clear.
Yeah.
So
Okay.
as is where is, Annapurna madam and Rajesh sir, can we say as is where is can be three types of as is where is?
Yes. Exempt and regularize. Exempt and clarify only. Okay. So depending upon the notification, can we interpret this into three different parts? That is what you're asking, is it? Depending upon the situation they are in, can it be in this manner? That is what you're
Yeah.
asking.
Correct.
Okay.
So that way,
So
whether the past can be taxable, not taxable.
yeah. Say for example, this fish meal, not fish meal, fish soluble paste, there was an exemption already in as is basis one in 2019. They gave an exemption. Okay. Now again in 2024, I think they gave this as is basis because the rate of tax issue was whether it is 5% or 18%. So there they issued a prospective exemption notification and gave this as is basis. Now the question, I mean, in your case, it can just go back to that slide, Venu. I mean, that whatever the previous one, the table. Yeah. Exempt for the future, I mean, and regularize the past only for the differential tax and not completely. That is what is coming out of that aspect of it. So that's a second category. Exempt and clarify, okay, wherein it is exempting for the future, clarifying the past to the extent of the differential only, and it cannot be completely exempted. I think I also have to go through this once again. But in the accommodation factor, since there is a decision, there is a possibility to take an argument. That is what I wanted to emphasize. That's all.
Correct.
Venu sir, can you read that last paragraph of that circular?
Yeah.
So, thus as recommended by GST Council, GST liability on the supply of accommodation services regularized on as is where is basis.
Yeah. So this is a exempt and regularize. This falls to the first category.
Yeah.
Because the circular is specifically saying it is regularized.
Okay. I understand. Regularize means actually there was a liability, but it's being regularized. That is the first
Uh-huh.
one.
ಒಂಥರ
Exempting for
11A
the
ತರ ಅಲ್ವಾ ಸರ್ 11A ಮಾಡಿದ್ರಲ್ಲ ಆ ತರ
obviously,
ಎಲ್ಲ
because for all this notification, I mean, all these things, there is no legal sanctity now.
ಹಾ
Okay, probably I'm expecting a notification after the enactment for all these things.
So now all as is basis circulars, we have to do it. But I really don't know. I would argue no new SCN for all the cases. Even when it is clarified, I'll say no new SCN.
Venu sir, maybe we can take up this itself as a topic. We can compile
See,
the circulars.
when as is basis, when they don't use the word regularize, that is what I emphasize, which Annapurna Kabra madam was talking about.
Artha aitu sir, but even though the word is regularized here, they have put a condition for a minimum continuous 90 period and 20,000 rupees.
No. I'm not talking about this notification. I'm telling the classification which comes under that issue of SCN. Okay.
No. What I'm saying, sir, even though the word regularized is there, this is exempt and clarify according to me for the accommodation service, not exempt and regularize.
No, so it will come
But
under exempt and regularize. It will
But-
come under-
They're
Even
not
if
even
but subject
clarifying
to the
this point.
collection
It is
of-
liable or not liable.
Even if I collect 50,000, no new SCN, is it?
Yes.
No. Venu, 1 minute.
Ah.
In this circular, there is never a clarification. In this circular, there is no clarification at all.
Correct.
So that is not coming to the second column at all.
Okay, it is coming only
Say,
in exempt and
for
regular.
example, in the 54th GST Council meeting,
Hmm.
the universities to board, that board to government schools,
correct.
one thing is there, no?
Ah,
There it is clarifying.
clarified that university is also educational institution.
No. That no, it is taxable. That what affiliation fee.
Affiliation fees, correct. Huh.
They're saying it is clarifying to be taxable, but as is basis they're giving you. Hello?
Yes, sir, got it.
So there may be a situation where that now if you see government schools only is exempt. Other than government school affiliation fee by the board is taxable for the past. So SCN will be issued there.
Hmm.
So it's a clarification, second column. Whereas in the this accommodation thing, there's no clarification. It's only explaining an exemption notification as is best thing.
Hello, sir, when there is a clarification of when sir is saying confirmed demand for what? The taxable portion.
Yeah.
Now, when there is a as is, where is, how can there be as is, where is then?
See, you have this this thing, no? That whatever that not education, that
I didn't pay
board.
tax on affiliation services.
Correct. You're a board.
Board.
I'm not talking about university. Okay.
Yeah. As is, where is, now they said historical.
Only for the as is based only for the government schools. For other schools, it becomes taxable. SCN will be issued.
Yeah, I think got your point. It's worth doing.
Yeah, research. I think we need to read back on this. It cannot be instantaneous.
Yeah, correct, exactly.
Annapurna. Hello.
Yeah, sir.
Okay. Annapurna. Okay. Kapra madam. The
There is-
context of the PAPAD was what, madam?
And there they have discussed on as is various basis. So they have told in that whatever the situation prevailed on the date when they have removed that and they have brought some exemption or levy. So whatever the situation present on that day, that will be applicable. So if the notice is not issued, like demand is not raised, then there is no demand. If the taxes are already paid, no refund. So indirectly, they are trying to clarify that where they are trying to stress in that they have disclosed as is basis, but in this accommodation they have added as is where is basis. So I am trying to interpret what do you mean by where? It means where it was on that day. Where was
No,
the situation?
I think what we can do, madam.
Yeah.
We have to list out
these whatever the various circulars in the
Yes, sir.
context
Yes, sir.
and the wordings, and also the representation which came up for the council.
Yes, sir.
So then if we compare, it's only a drafting, they're considering all these three as synonyms, or there is something separate in each of them. If
Yes, sir.
they're interchangeably being used, then I think we need not worry too much into as is basis within inverted comma, or
Yes, sir.
as is where is basis. So I think we can first come to that conclusion. Then I think
Yeah.
Jatin sir's analysis also I will have to go through it, because
Yes, sir.
I have to still understand what he meant. If he was there, would have explained us that which are all the situations where the show cause notice will be issued.
Yes, sir. Even in few cases, it is in the audit proceeding stage, sir. Like ADT 1 is already issued, and we are replying based on this. So whether that can also get dropped. So not only at the SCN stage, even at the audit proceeding cases
So
also.
I
they are
think
pending.
practically, madam, I have experienced that once this clarification comes and circulars comes, they're dropping the demands.
Yes, sir.
Either in
They're
whichever
dropping,
the
sir.
stage, whichever the
Yes,
stage
yes.
it is in. But the
Yes, sir.
confusion is lying in these type of as is basis, that is,
Yes, sir.
accommodation services, where part
Yes,
of
sir.
it only part of it is covered under that relaxation, but the other part is not covered under relaxation. It is not
Yes.
fully relaxation. Those are certain, I think around 3-4 scenarios may come where
Yeah.
this problem may arise.
Yes, and I heard from somewhere from the senior saying that they will come out with a specific clarification as a circular itself to clarify what do you mean by what are the scenarios where they are going to give that benefit. So that is what
because
I
I
know,
think
but-
that representation has gone from
Yeah.
one of the industries which I was mentioning, that is a fish meal
Yes, sir.
industry.
Yes, sir.
That recommend, I mean, that request has gone them to
Yes, sir.
clarify this positioning. In fact, it was
Yes, sir.
supposed to have come in this council meeting, the clarification,
Yes,
but
sir.
it did
Yes,
not happen. Probably by next council meeting, it should come out.
Yes,
They're
sir.
putting
Yes,
up
yes.
before the council.
Correct, sir. So that was one more thing, sir. So we have to wait and see. I've just shared that Gujarat decision which I was reading on that
Yeah,
as is. So okay.
Okay. Right.
Thank you.
Kavra
But,
madam,
in
shall
nutshell,
we?
sir, whatever may be the stage it is in, whether SCN issued or not issued, for the past thing, like, for the past mistakes, they cannot raise any demand. At the same time, refund also cannot be claimed.
Yes,
Yes.
yes,
Can we take
that's
it
the
that way?
concept
So
of,
whatever
that is
may
the
be the
concept.
case, whether you have charged
Yes,
50,000, 80,000, whatever may be
correct,
the
correct.
case. Okay.
Yes, that is a concept of this.
No,
Yes, sir.
this
No.
particular aspect is clarified in
Mm.
the first meeting
Mm.
where they use this as is basis.
Mm.
They've said in which what they meant is there's no need of further demands, but if some taxes is already paid, that cannot be recovered.
Yeah, okay.
I mean, sorry, it
Sir,
cannot be claimed as demand.
Refunded.
What is the number of the meetings, sir? You remember by any chance, sir?
No, I don't remember, but I
Okay.
think because we were
90.
surprised when this word was used, and we were also wondering
What?
uh,
it means.
how can this type of clarity can come, and in fact we're waiting for a notifications to come for the same in our validation provision in the act. In fact, initially this type of retrospective thing which they brought in a validation provision in the act, finance act, in the subsequent thing. Okay, initial when we made a representation firstly for the past period, okay, it was for fish meal industry. At that point in time, we have ourselves were hesitant. How can they give when there is no provision? It happened. So we were surprised by ourselves that it happened. And when it happened, then council meeting decided, and there was a corresponding provision in the Finance Act in the subsequent period. I mean, subsequent budget. We were expecting the similar thing for the future things, but after this as is basis concept started emerging later on. So then where this issue was there, how can they give that relaxation when there is no authority in the act? That is when this 11A is now introduced. Probably I'm expecting for all these past circulars to validate. Either there will be something coming out is what I'm expecting. I don't know whether merely by circulars.
That happened, sir, in the council meeting. They are validating all the past notifications which they have been issued.
No,
That
madam,
is
I'm
being
not telling
getting
that.
ratified.
what I'm telling Venu, in the act presently, in the statute,
Ah.
statutorily there is no notification giving you that relaxation.
So,
One of the
sir, you're
one of
saying that.
one of the officers said, no, give me a notification. I am not going to go with circular.
Okay.
So all
It-
these clarifactory circulars will be backed by 11A notifications is
It
what you
should be.
mean.
It should be is what I am trying to, because otherwise,
Mm.
where's the validating?
No sanctity, yeah.
There should be some notification validating all those things. There should be one consolidated thing probably. There I am.
Only for the past.
Yeah, obviously. Future anyhow, again there will be notification. 11A.
No.
Once-
Only for those before 11A.
Yeah, once the 11A comes also, there is going to be a specific notification straight away coming in. That doesn't
Got it.
require a finance, act,
Right.
legislature approval of a state
Got it.
or union parliament.
Ah.
So that doesn't require. But for the past, future after 11A gets enacted and become effective, then government will immediately issue a notification under that particular section for that as is basis thing.
Sir, but in that press meet, no, the finance secretary was saying 11A will not be used leniently or liberally. It will be used only for some particular cases.
Yes, madam. Now also what is being used is not, as per them, it is not leniently. It will be thing, because for the wherever the representation is strong, they are giving, because all these are initial period of settling of this law to the economy. So you can't expect that to be so frequently coming after all the sector have been covered once. And because now we are crying, we were not aware, we were past, this was a confusion and all those things. But again, this will be used as a lobbying mechanism in the future, because we have seen in the central excise as well, 11C notification was, section was there, where, the strong lobby used to get that notification.
Oh, so all these things will come through 11A. Is that what you mean to say?
Yeah. See, there may be issues in various sectors, but if you see, you will get this as is basis for smaller issues, which you say, oh, this issue was existing, we feel. But there may be 100 more than more issues which commonly people are suffering, which nobody will be worried unless somebody pushes it in through that particular system, through a secretary or a council, those procedures. Who knows a bureaucratic procedure will be able to get these things better than merely writing in open forums, etc.
Okay.
So because whatever the industry which I have worked with, where this type of 11C notifications have, 11C, not 11C, basically all this as is basis have come out. I know, there is some direct connect somewhere either in the CBC or the council. Some known person has pushed for it.
Sir, one doubt, sir, in excise also we had this 11C, 11D, and now
11C.
there was no 11C, and there was a refund, I think, which was there in that section, but that is not there in 11A section. And there was no concept of as is, where is basis in excise or service tax. So now there is one more thought, that whether this as is, where is basis will fit into 11A, or will there be a specific power which will be given under 168 or 148, saying that this is a special power which has been given by the government to give an exemption for the past transaction.
Madam, 148 circular, which you
Yeah.
are referring, that is a poverty issue circular, right?
Yeah.
So,
issue.
poverty
Section.
issue circular, I think Ratan melting
Melting
decision,
case, yeah.
Supreme Court you have to read.
Yes.
I think last 3 paragraphs or 4 paragraphs. Okay.
Yeah.
I invite you all to read, where they do say there was an argument taken. Once there's a circular, you should not insist. You should insist that to be followed strictly by the authority officer. Okay.
Yeah,
Who are
but
the
I
adjudicating?
I agree with you, sir. But anyway, now
No, I'm not completed. I've not completed my argument. Okay.
okay.
Yeah,
Tell me.
what is that
Yeah.
I'm trying to say is, there they say that was an argument taken by the advocates. So the court says, no, we can't accept this particular, argument, because if we say so, we are taking away the fundamental right of, litigation from the departmental authorities. So they say you cannot insist for that. Okay, if any circular which is not in accordance with the law is as
Yes,
good as
sir.
non-existing. So
Yes, sir.
if any authority would like to take such stand that it is not, you cannot come in their way and say that no, there's a circular, you are bound by the circular, you should follow it. You should
Correct,
not
sir.
insist. That is what has been
Yes, sir. Given in judgment, yeah.
given the judgment. So I'm
Yes,
just
sir.
trying to say,
This is contrary to the Dhiren chemicals, no, sir?
no, this is a further, that was, this is a larger bench, constitutional
Yeah.
bench. Dhiren
Yes, sir.
chemicals issue was put
Correct,
down,
yeah.
and
Mm.
this was the proposition which was held.
Yes.
Okay.
And this is
Constitutional bench.
holding today, yeah. This is
Yeah. This is
holding
this is a decision which is holding the field today.
yeah, today, yeah.
Okay.
So all our illegal circulars will be
No, I'm
hanging,
telling, see, the
yeah.
authorities are following. Some cranky officer comes up, then the issue will go up. See, some officers, practically what happens, the issues will not crop up unless there is some ego issue coming in between the officer and the taxpayer. So that officer will take up, okay, I will take up, you do whatever you want. Then the matter goes up. Finally, it lands somewhere. Otherwise, generally, it will be, circulars will be followed. Okay. So I'm just telling, Jatin sir always says, no, that circulars, though it is illegal, we can take advantage of it in some places. So we should use that
Unless
as a tool.
it is rescinded.
Yeah. Okay.
Yeah.
See, the purpose of the discussion here in this forum is to understand the correct position of law. What you use, what argument we take, how we handle it is a different scenario. I mean, different, thing altogether. Where, I mean, emphasis should be not on that aspect of it. Emphasis should be to understand the position of law and understand where it stands. Okay. So that gives you a fair view. Okay, it is not there. So still I am taking a ground, still taking an argument. So that is how it goes. This restaurant definition, I think I joined late. Sorry, I couldn't attend because I saw the time wrongly. It was 8:30. I mean, around 8 o'clock. I was thinking it was 7 o'clock, so I joined at 9 o'clock. Okay. The point was a restaurant definition. I think there is some words there. I think everything cannot fit in a restaurant is one of the opinion I was examining. I do not have a definition print of me, but I'm just trying to say the scope there is limited and it cannot be applied to anything and everything sort of. Okay. Right. Thank you. When anything else?
Kabra madam, you're there, no? Hello.
Yeah. Tell me.
Madam, shall we jointly take up this, compile all these connected circulars and work with some scenarios to say which fits in where SEN is possible and all that? Can we take it up?
Yeah, we'll discuss
Do
with
some
you.
home. Yeah.
We'll discuss
Okay.
with you.
Yeah.
Sir, Rajesh sir, how was
Yes, ma'am.
position in service tax time, sir? Like, because when GST was introduced, when you looked at this exemption notification, definitely you would have realized that this is going to, be a litigative issue, right, sir?
See, the cases on that in the service tax is still going on. In fact, we are using a GST decision of Tagore Vasudev in the service tax regime. See, the advantage of GST law is it is moving faster because of the circulars, council meetings, etc., and the decisions coming to High Court. But in service tax regime, any decision to take some shape, it used to take a lot of time. So that was not there's not a case in the GST because too many people are knocking the door of the court or to the council or the clarification, representation. I think that is where positions are getting more open up in the GST law. We are getting into that.
Oh, the service tax was not this aggressive, huh?
No.
Oh.
No, issue and
So
take it.
1,000 rupees per day was also continued, sir, in that.
But no conclusive decision, na?
Yeah, correct. But still, that was like how they
That issue
removed
is still
in,
there.
yeah, that
No,
is still there.
Still there. The issues are still going
Yeah.
on. What I'm trying to
Yeah.
say, rather than using a service tax law in a GST law, we will be using GST
Vice versa.
decision circular for the service tax cases which are pending in the tribunal.
Oh, to take the conclusive direction, sir. Okay.
Yes. Okay.
Thank you.
Thank
sir.
you. Thank you.
Good
Thank
day.
you.
Bye.
Thank you.
Thank
Thank
you.
you all.
Thank you, Sujata. Thank you all. Bye.